Good morning. I will now call the session of the Board of Revision to order. I'd like to make the following statement. We're acknowledging that we are in Treaty 1 territory, the traditional homeland of the Métis Nation. With me on our panel is Stuart McPherson, farthest to my left, Carrie Linkletter to my left directly. My name is Harvey Diamond. The city is represented by Cam Wong, who is the assessor, and our coordinator here is Kara Balshaw. We'll be hearing applications for revision of the assessment rules in accordance with the Municipal Assessment Act. The matters for which revision have been requested are described in each application. We will limit discussion to those matters. The statements that applicants or the assessor may make at this hearing shall be sworn in testimony, and anyone speaking must be sworn in. Be advised that comparison of assessments of properties are not considered evidence of market value by our board. Our board is appointed annually by council and is independent of it and the city administration. We make our decision on the basis of the evidence that we hear, and we issue written orders that will be mailed to the parties as soon as possible. Please note that our decisions with respect to an application may be appealed to the Municipal Board of the Province of Manitoba if the matter pertains to assessed value or classification, or to the Court of Queen's Bench if the matter pertains to an application for exemption from taxation. And should a party wish to appeal, information how to do so will be included with our order. With respect to the hearing process, I will confirm the matter to be addressed to each applicant following that party swearing in. We shall then have the assessor's testimony followed by questions that the applicant may have or our board may have, after which the applicant's testimony will be provided and any questions that may be had by any parties regarding his or her matters and evidence. Once all the evidence in the application has been brought forward, that party may leave. The process will repeat for each item on the docket today. And after all matters are heard, we will close this hearing. We will make our decisions in private, and we will send our decisions by registered mail as soon as possible. And this is a public hearing. It's being live streamed and recorded and form part of a live record. Thank you, and we'll swear the parties in, please, Carol.
Please state your name.
Cam Wong.
Do you affirm the evidence you present today is the truth, the whole truth, and nothing but the truth? Thank you. Please swear in.
Swear.
Please state your name.
Jared Story.
Do you swear the evidence you'll present today is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Okay, so we have one matter on the agenda, Mr. Wong, and we can proceed when you're ready.
Sure. The subject property is 161 Langside. The roll number is 120-909-090-00. We actually are agreeing on the value. Like I have a recommendation on here, and Mr. Story and I are in agreement on the value. There is just a matter of non-compliance in.
Can you like to tell us the value that you're recommending?
Sure. The value is it's on my brief at the bottom. On first page on the bottom. $2,647,000.
Thank you.
Excuse me, Cam, in our discussions, on your sheet, we have a different value though, right? I have $2,587,926.
Do we have an agreement?
It's in your email, I think, right, you wrote this in.
Yeah, can I see it?
Yeah.
Sure, absolutely.
I'm sorry, the value is $2,588,000.
Okay.
And that's based off of an adjustment of the net operating income. very similar to, I guess, what I have on my page 3.
Okay, so on page 3, you got a value of 2,647, you obviously revamped it, you'll take us through it after.
Yeah,
That's
yeah.
right.
Then we're seeking non-compliance on this particular property because we requested income and expense information, and it was not submitted until months after it was to be returned to us.
Okay, so it was requested the normal time, and when did you finally receive that information?
Well, initially we requested it in April, and then we requested it again, I think in June, and we received it in on August 30th.
Okay, so you see it August 30th, and so you didn't receive it in time for the mass appraisals, but you did receive it in time to prepare for this hearing, correct?
Yes.
Okay,
Yes.
okay, and so your argument is that because you didn't receive it for mass appraisals, there's been some damage done to the city of Winnipeg, and you're seeking penalties for that? Is that your position?
The position is, we request this information, and it is, we ask that it be returned to us in a, I believe it's 21 days, and,
Okay, it does indicate that it's requested within 21 days, an initial information then,
yeah,
okay.
yeah.
Does it indicate that penalties could be assessed if it's not provided in that time span?
Pardon me?
Does it indicate that penalties could be sought if it's not submitted in that time span?
Yes, it does.
Okay. Okay,
And it's on my page 19.
okay. Okay, well, that's fine, thanks for providing it to us. Anything else that you wanted to say before I let Mr. Story respond?
No.
Okay, Mr. Story, your position on the application by the city?
Yes, firstly, I have Altus's position on the application of penalties. May I distribute copies in my?
Absolutely, if it's part of your summation right now, or your argument right now, absolutely.
Documents.
Okay.
Thank you. Okay.
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 First, yours.
Thank you. So the assessment department is requesting that the owner is penalized for a late submission of the income and expense questionnaire. The assessor's evidence, as he's just said, implies that the due date for the questionnaire was April 12th, 2018. But the tracking is certified mail delivery sheet, which is on page, correct? That's page, oops, I'm sorry, page 17 and 18. Pages 17 and 18 would indicate that that letter appears to have been signed for on June 7th, which is odd because it also, there's some tracking information that makes reference to June 8th. So I'm
Correct.
not
I see that.
sure what happened there, but so there's some confusion that arises here because there was a changeover in property management companies. You'll notice also that in the submission, which again was submitted on August 29th or 30th, see that the financial information that makes up a full year, the first, let's go to page, if you'll follow me here onto page 9 of the assessor's brief, you'll see that the statements from January 1st to August 31st of 2017 were provided by Wind Park Dorchester Properties. next page, page 11, you'll see that the period covering September 1st, 2017 to the end of the year was provided by Sussex. Now, Sussex is the current property manager. So it would appear that the scenario is that there's an interruption that occurs during the change of management. And it would appear that Sussex acted in good faith in ensuring that accurate and clear information was submitted. Now, the spirit of the act would only have the application of severe penalties in very limited circumstances. The municipal board has clearly indicated that the penalty should not be granted if there's been substantial compliance with the assessor's request for information, which is true in this case. They have complied, they were tardy, but they were not non-compliant. The board indicates that the penalty would typically only have application where service of the request has been properly made and where the taxpayer has made no attempt to reply in sufficient time for the assessor to use the information in making the assessment under appeal. The relevant provisions of the Act are as follows. Under Section 16(1), an assessor may request that a person, including a Crown agency or Crown corporation who owns, uses, or occupies assessable property, provide to the assessor information or documentation that relates to or might relate to, or that affects or might affect the value of the property being assessed, or that is or might be relevant to assessment of the property, which, without limiting the generality of the foregoing, may include information for each year since the previous assessment. This is in respect to any sale of the property, the cost of any construction on the property, and any income or expense related to the use or operation of the property. In the next section, 16(2), under the heading Time to Provide Information and Declaration, the Act says, where a person, including a Crown agency or Crown corporation, receives a written request from an assessor under subsection 1, the person shall, within 21 days of receiving the request, provide information or documentation to the extent that information or documentation to which the request relates is in the possession or control of the person, and shall provide in the form of a side statement a declaration of the person affirming the information or documentation provided by the person is complete, true, and accurate. And again, this speaks to my point that at the time of the request, the current property management company was not likely in possession of this accurate information. Section 53(3) states, Section 54, subsection 3(2) states that the effect of providing no information where a person failed to comply with a request for information or documentation under clause 16(1)(c), the board or panel shall specify in its order that any reduction in the assessed value of the person's property is not to take effect until the year following the year to which the application relates. Okay, now, when they speak about substantial compliance, the Act says, as set forth above, it is only where the board finds that there has been a complete failure to comply with the information requested under Section 16(1) that the penalty under Section 54 is application. The most obvious example being where no information whatsoever has been sent in by the taxpayer in response to a proper request. However, we submit that if a taxpayer supplies the requested information in time for the assessor to take that information into account in preparing the assessment under examination, there is quote-unquote substantial compliance by the taxpayer. The penalty should not be applied, as the objectives of the legislation are met in these circumstances. Now, in terms of precedent, the leading municipal board decision concerning the principles of substantial compliance come from Board Order number A98448. This is, of course, included in the submission that I've given you today. In this decision, the board found as follows. Time for compliance may be read into the penalty provision. The demand was not made for the purpose of making the assessment under appeal and could therefore not be relied upon for requesting the penalty. The board stated in its order as follows. The owner says that for the penalty provisions to apply, a demand for information must strictly comply with Section 16. A demand that does not strictly comply with Section 16 is invalid and the penalty does not apply. The owner says that the assessor may only make a demand for the purposes of making an assessment. The owner says the penalty provision is not tied to the requirement to respond within 21 days as set out in Section 16, subsection 2. The board finds that because the assessor admitted that the roll was closed when the demand for information was made, the demand could not have been made for the purpose of making the 1998 assessment. As such, the assessor cannot rely on that demand to support the application of Section 60. The subsection 2.2 with respect to the assessment. The owner made a number of arguments with respect to the assessor's suggested interpretation and application of section 60 subsections 2.2. The owner suggests that the information is supplied more than 21 days after the demand, but in a timely way, the board ought to have discretion whether to apply the penalty. The board also finds that the time for compliance may be read into section 60 subsection 2.2, where the board agrees with the owner that only where the information is not provided in a timely way for use in preparing the general assessment would be section 62 to have application. The approach to statutory interpretation was set forth by the municipal board in, again, board order number A98448. As quoted above, and is fully supported by the leading Supreme Court decisions. The Supreme Court of Canada in Bon Secours versus Communauté Urbaine de Québec elaborated on the modern principles of statutory interpretation of tax legislation. The court cited the comments of Etsy and the Queen versus Golden as follows. In Stubert, the court recognized that in the construction of taxation statutes, the law is not confined to a literal and virtually meaningless interpretation of the act, where words will support on a broader construction a conclusion which is workable in harmony with the evident purposes of the act in question. Strict construction in the historic sense no longer finds a place in the canons of interpretation applicable to taxation statutes in an era such as the present, where taxation serves many purposes in addition to the old and traditional object of raising the cost of government from a somewhat enthusiastic public. Further to this, the court cited Dixon, CJ, and Broughton Trust versus the Queen concerning the trend away from strict construction of taxation statutes, and then stated the following. In light of this passage, there is no longer any doubt that the interpretation of tax legislation should be subject to the ordinary rules of construction. At page 87 of his text, Construction of Statutes, Dreger fittingly summarizes the basic principles. Quote, the words of an act are to be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. We therefore submit that the rationale set forth by the municipal board is entirely reasonable and consistent with the objective of the legislation, which is to obtain the necessary information in sufficient time and to use it when making the assessment. The Court of Appeal has also commented on the issue of substantial compliance in the city of Winnipeg. This is commonly known as the Lickerson case, where the city assessor versus Lickerson et al. Say that, or in that case, the court makes the following observations. The purpose of the legislation appears to be this. The assessor must complete the assessment roll by a certain timetable. Once the assessment roll is completed, the tax obligation of the individual property owner can be determined. The property owner is then entitled to appeal the assessment. If the owner fails to provide the information to the assessor as requested, and is successful in reducing the assessment, it distorts the city's budget due to an unanticipated reduction in taxes. The statute thus imposes a deferral of the reduced assessment. There's a general agreement that requests for information concerning income and expenses are sent out so that information will be available to the assessor as the general assessment roll is being prepared. As long as the assessor receives the information before completing the assessment roll, the assessor is usually content. The whole purpose of the legislation is to facilitate the gathering of information so that the general assessment roll can be completed on a timely basis. The concern of the assessor is not to punish the owner who fails to respond, but rather to not be blindsided by a subsequent appeal. Particularly an appeal to the Board of Revision or the Municipal Board where the information was initially withheld or inadequately provided. And lastly, in the Municipal Board Order A06343, the board commented that the solicitor for the city assessor, quote, noted the Court of Appeal had determined that if the requested information is provided after the 21-day requirement, but before the assessment rolls are closed, there is substantial compliance. Where a taxpayer has made reasonable efforts to comply with the assessor's request, such that the objects of the act are met, there is substantial compliance and the penalty should not be applied. Reasonable efforts would include the provision of the requested information to the assessor in sufficient time for him to use the information made from the assessments. So, with all that being said, we believe that our client acted in good faith, submitted clear and accurate information, and did so in enough time that the assessor was able to be content in terms of completing the role by their timetable. Thank you.
Thank you. Yes, you have a response, Mr. Wong?
No.
Okay, well, we'll have to make a decision on this. I'm sorry,
May I ask
you have questions, sir? Absolutely, any questions, I'm sorry.
I'm sorry, I did just have a couple
No,
of questions.
absolutely, thanks.
First, a comment
Sure.
on the brief that you provided us. I'm missing a bunch of letters and numbers
Letters
in the
and numbers.
text,
Oh,
so perhaps you could
let me check.
check it, make
Yeah.
sure you're in the path, because some of them refer to board order numbers that
Right.
aren't
Oh, okay.
complete, so,
I will check that.
yeah,
and get back.
pages 4 and 5
Okay.
in particular. I guess some of the questions I have is actually for the assessor as well, Mr.
And you can
Chairman.
direct them wherever you, because we're gonna make a
Just ask
decision.
whoever I think.
Absolutely.
Okay, so I guess the first question is, you're saying that you believe that this information was provided to the assessment department in time for them to prepare the general assessment or
Correct.
the specific assessment of this property?
Both. That'd be both.
Okay, so you're saying that it was like the end of August that it was
August
submitted?
29th, 30th.
Okay, and then I guess my question to the assessor is, when do you prepare the general assessment? When does that process start?
I believe, I have to be honest, I'm not 100% certain, but I believe it starts at around that time frame. Or it is, it probably has started well before that, but with regards to maybe analyzing the information and then producing the model which estimates our values, I'm actually not sure about the schedule of the generation of the model.
Well, assuming that these applications have to come in way before August, the end of August, it must have been done before then, because it's only early September right now, we're September the 5th. I can't imagine that this application must have been put in way before.
I'm sorry, Mr. Chairman, it's August of 18 that was submitted, was it not?
Yeah.
August 18th, okay, yeah, okay, so I'm just
Yeah.
thinking
Date
of,
on the 18th.
yeah.
Yeah.
So almost a year ago is the time frame.
Oh, we're talking about a year, I'm sorry, you're right, okay.
I think the notice of assessment actually comes out at about that time, so it's possible that they could have, like in the September timeframe, it's possible that they could have finalized the model before that and maybe needed the information even prior to August. That's just what I think, because to sort of come up with the values after that, like for 2018, to not have the values even earlier, assuming it needed to be ready, that the values needed to be ready by August, if they would have been analyzing the information much prior to that. But once again, like I said, I do not know the schedule for which the model values were derived.
So you're saying there's a general mailing in April, is that correct?
Yes,
And that's sent to all property owners or
yes,
their agents, whoever's on record to receive?
yes, all property owners.
Right.
Or income producing properties, yeah.
So that's sent in April, and then supposedly you get the majority of those responses prior to June. If you don't have them, you follow up with registered mail, is that correct?
Yes, we try in April, and if we don't receive a response, we send out another notice in June, and I believe it's in June. We send out a second certified request for information, and
Sorry, a second certified one, or a second one is certified?
the second one is certified.
Okay.
Yeah, and then if we don't receive a response after that request, then that's it. I mean, I think I don't even think that we're obligated to send a second request, but we do it to try to be as courteous as we can, I guess, to try to get the information. So yeah, that is the process for requesting information.
Okay, and this is probably a question you can't answer, but I'm gonna ask it anyway. Do you know when this particular property, the assessment was set for this property?
I don't know. But, yeah, I mean, to sort of sum up, just, we requested the information twice and it was not, responded to in both requests. And to say, you know, it was, there was a response sent several months down the line, but, you know, to be like, it could have been, in this case, it ended up being 2 months, but it could have been 3 or 4 or 5 months or a year or two. We requested the information twice, and and nothing was returned for either one within the requested time frame.
Okay, and Mr. Story,
Yeah.
you said that there was a change in management
Yes.
companies from Windpark to Sussex.
That's correct.
Is it your contention therefore that was part of the reason for the delay?
Absolutely. Sussex is clearly one of the largest property management companies in the city. They're not in the habit of being non-compliant. So the only difference that would occur there is that there was a change in management. I would suggest that there was some difficulty perhaps in obtaining some of the information from the past property manager. There's also, there have been decisions in the past that talk about that would be improper or unjust on some level or unduly harsh to punish the current owner for the actions of a past agent who's not necessarily invested in having this information submitted. And I do believe that Sussex acted properly in terms of providing clear, accurate, and complete information at the time when they have it.
Right, but I see on your page, or the assessor's page 11, it was September 1st, I guess, of 17 that Sussex took over?
September 1st of 17, yeah, that's correct. But I don't know, in terms of the transition, I'm not sure if all the files were, I'm not sure how cooperative the past property manager might have been in terms of handing over the prior information. That's
So
the question in my mind.
would it not have been possible for the current property manager to submit what they have with an explanation that they're trying to retrieve the other?
We'd be sitting here talking about non-compliance in much the same way. That's indeed.
I don't think so necessarily, because they would have made every attempt
It would
to
likely be
do it within the
considered-
time frame.
It would likely be considered an incomplete submission. And if they only had September to December, I mean, that would be, I would not be surprised if we ended up speaking about non-compliance. So I think that they did what seemed, they did what seems to be the most appropriate course of action by submitting, again, full, clear, and accurate statements that are meant to help the assessment department with their modeling.
Okay. Whether it be speaking about it or not, the outcome may be different, different circumstances. Thank you, Mr.
Thank
Chairman.
you. Does anybody have any questions?
Yes, I just have a couple. So, Mr. Wong, on page 19 of your brief, this is the letter that you sent out April 12th, stating that this information needs to be returned by May 3rd, correct?
Yes.
Okay. And when you get a non-response, then you send out a registered mailer on page 18 of your brief, 17 and 18. So you sent out something June the 8th, 2018? That's the date stamp on me.
I believe so, yes.
Okay. So, and does that contain a copy of the letter from April 12th again on page 19 of your brief?
Actually, honestly, I believe that it's actually a different one with a different date on it.
Okay. So do you know what that date is? Like a date of return? Because the letter dated April 12th says it needs to be returned by May 3rd.
Mm-hmm.
So I'm just wondering,
It would have been late June, like June 26th or 8th or around.
Okay. But you don't have a copy of that letter?
I do not.
Okay, and Mr. Story,
Yes.
the person who has signed for this on page 18 of the city's brief is an L. Zhang.
That's correct.
And do you have any knowledge of who L. Zhang is?
We believe, and I haven't had confirmation from Sussex that that's an employee. I have reason to believe that it is an employee, but again, no confirmation. And that's based on the fact that someone in our office has said that they've seen the name Zhang in relation to Sussex before. So that's an interesting question, though. That's something that we looked at very closely, because the Sussex property is actually, there's residential, and there's all kinds of people in that building. So we thought at first, is it possible that somebody inappropriate signed for it? But our best guess would lead us to believe that L. Zhang is an employee of Sussex, but again, that's unconfirmed.
Okay. And page 17 of the, Mr. Wong's, is 274 Osborne Street North, is that the correct address for Sussex?
Yes, it is. I believe it is. I'd have to double check, but I believe it is, yes.
Okay.
That's the mall plaza.
And Sussex took over the management from, is it Wynn?
Wynn Park, Dorchester.
Dorchester? You said in September of 17?
Sometime in 2017, yes.
Okay, thank you, that's all my questions.
Okay, so Mr. Story, you're indicating that because of the fact that Winnipeg, Dorchester, which you said were not cooperative with the new manager Sussex and didn't provide information to them, you know that for a fact?
I don't know that for a fact. I'm saying
Okay, that's an assumption then?
That's an assumption.
Okay, and but let's suppose that they were upset about losing the management, and they were cooperating, and were basically negligent in not looking after a former client that led to this hearing today.
Okay.
And then if we were to agree that there is non-compliance, there'd be a loss to the property owner.
Correct.
And you're saying that's unfair, but wouldn't the property owner, in that instance, have a right of action against Winnipeg, Dorchester for the non-compliance that cost them?
Right. You know what, I'm not, again.
I mean, that's what the law's there for, isn't it?
Not qualified to say.
Yeah, but I'm just saying, isn't that what the law's there for?
Perhaps.
Yeah. So, okay, that's my question, thanks. Any other questions before we
Good, thank you.
set it? Okay. So maybe since there's only two of you, you can leave the room and walk.
Oh, for
Sure. About a decision.
Wonderful.
I'll just
Yeah.
switch the camera.
Okay, we have reached a decision. It was not an easy one to reach, I gotta tell you, and we were all torn on it. But the fact of the matter is that we feel that the situation is such that we have to have some consistency, and so this is what we're deciding. But Mr. Wong, we would like to very much have seen that second letter, because it would have an exact end date, which you know, in fact, that it would be sometime at the end of June. We don't know when it's the end of June. And when you're talking about, which the applicant has asked for, was something that he's asked for substantial compliance. And that letter would help us if the date was proximity to perhaps maybe when that, when the information is finally advanced and provided. But in any event, we look at it this way. The first letter went out, and certainly it went out originally requiring that the termination and the information be provided within 21 days. The city then, sometime later in June, sends out a second request. So certainly, if anything was provided in time for that second request, there would be compliance, because the city has extended the time span past that 21 days in the original letter, and that'd be compliance, not even substantial compliance. But our position is that we don't know when, if you're talking about substantial compliance, when is substantial compliance? Is it if you submit a date after the second termination, a month after, 6 weeks after? So we have to have an end date so there can be consistency. And we feel that that end date would have to be the date that would be in that second letter, 21 days after. And we're saying that because the second letter is already giving an extension of time. It's offering you the right to make substantial compliance because you didn't comply with the first letter. But Mr. Wong, again, we would like to have seen that second letter in the future. I think that officers should provide them when seeking these positions. But we're gonna grant the order of non-compliance on that basis. And I gotta tell you, we were torn, but that's where we're at. Okay. Any of my board members, if they have anything else they want to add, I'd like me to do so. Okay.
Well, appreciate your time.
Thank you for yours.
Very much.